Good afternoon, everyone. I had to remind myself to say afternoon there because we are pre-recording this. It's the morning time. But this is a pre-recorded episode, so unfortunately, the little Q&A box won't be there. So if you do have any questions, you can save them up and ask. If you have LinkedIn, actually, we were talking about this before, weren't we, Ben? Ben's somewhat of a legal influencer now on
Stop
LinkedIn.
it.
So, if anyone has any questions or comments about the episode, if you post them to LinkedIn, or if you want more information about something that we haven't dealt with enough, then you can ask Ben to deal with them in one of his mini clips that you've been doing, Ben.
Yeah, I will credit any questions that you ask when I provide the answers.
Yeah, well, Ben's become famous in his own right. Anyway, but I'm off topic already. I'm only back 2 minutes. I'm off topic. Good afternoon, everyone. Welcome to Stewarts Soundbites. Joined today by Ben Townsend, a partner at Stewarts. You'll all know Ben already. He needs no introduction. And as I said, he's already virtually famous himself because he's been doing these brilliant videos, kind of mini clips on LinkedIn. And do you respond to requests, Ben? Is that what you mainly do?
Yes, most of the time when I'm doing my little videos, I'm mainly answering people's questions. And when I do answer people's questions, I do credit the questioner.
Is
So
that
do keep
important? Do
them
people
coming
are,
because
are
it's
people
helpful.
okay, okay, yeah, yeah, definitely. Do people ask you, make sure you credit the question? I suppose then they know you're answering them particularly.
Yeah.
Ah, got you, okay. Anyway, today we're talking about case management. We're talking particularly about single instructions versus joint instructions. And this is something that I thought I wanted to deal with because I've had lots of conversations with different case managers about different practices, about how these things work practically, and about how they are approached by different solicitors and different case managers and different defendants and insurers. It's like there's quite a wide spectrum. So I wanted to take today to talk about well, the lead up to that question, I suppose, which is the introduction of why, what we consider when we're looking at whether it's going to be a single or joint instruction, all the pros and cons, and ultimately, hopefully, provide people with some practical and useful information. So we've only got 15 minutes. I've already spent about a third of that talking nonsense, so I'm just going to start. Um, Ben, so deciding at the outset about instructing a case manager, what are the factors and what influences us as solicitors and us in advising our clients as to whether we're going to singly instruct a case manager or jointly?
Well, generally speaking, it's better from the claimant's point of view to have a singly instructed case manager, usually. One of the benefits of having a singly instructed case manager is that you've got direct access to the case manager, so you can have a quiet chat with the case manager. The other thing that's real benefit of having a singly instructed case manager is you can take a witness statement from them and you can have them along to conferences with counsel and experts where their input can be valuable. Now, you can't do any of that stuff uh, on the face of it when it's a joint instruction. The joint instruction can be useful, though, as a compromise situation when you're trying to build a relationship with the defendants. And it's something that you may need to concede where your case isn't as strong.
Mm. So with and by that you mean the kind of the liability position isn't as clear cut, then you might be in a position where the defendants are insisting on it and you kind of acquiesce, I suppose you'd say, yeah.
Yeah, I mean, if you've got a nailed on 100% case, then you will probably need to make fewer concessions, and a singly instructed case manager may be something that you want to press for. Whereas if you've got a case that has an obvious defense, it may not ultimately be successful, but there is a defense there, then you're having to negotiate your way around things a bit more. You may just have to concede a joint instruction of the
Mhm.
case manager.
Yeah, yeah. And I mean, it's interesting for client from a client's perspective, isn't it? Because almost all the clients that we deal with never expect to be in the position that they end up in, let alone have considered the basis of instruction for a
Mm.
case manager. So explaining that to the client, I find, is quite important at the beginning, and the kind of pros and cons, which we'll come on to in a bit more detail. Um, but well, as a starting point, Ben, what is interesting, I remind myself about this. I do have the rehab code saved to my favorites. I don't know whether that's sad or not, but I do.
Not at
Uh,
all, Emma.
yeah. And I wondered whether we could just go back to that basic starting point, and what does the rehab code say about single instruction and joint instructions?
Well, just for anybody who's listening and might not be au fait with the detail of the rehab code, the rehab code is basically just a framework that solicitors work around that governs the early stages of rehabilitation on a case. Now, under the rehabilitation framework, essentially, if you're working under that, the parties agree upon the rehabilitation that the claimant needs, and the defendant pays for the agreed rehabilitation. So it is a useful framework to make use of. Now, a lot of insurance companies, and even a lot of claimant solicitors, tend to assume that if you're working under the rehabilitation code, that you automatically have to agree to a joint instruction of the case manager, and that isn't correct. It gives you the freedom to agree either a single instruction or a joint instruction under the rehabilitation code, and it's important that the claimant solicitor bears that choice in mind and doesn't automatically assume that they're working under the rehab code, so they must do a joint instruction. The
Yeah.
other thing to think about is that even if you concede perhaps the initial immediate needs assessment being done under the rehab code as a joint instruction, you may leave it open that you're going to move to a single instruction at a later point.
Mm. And the rehab code says, doesn't it, that the joint instruction might maximize the benefits of collaborative working, and I think probably in some cases that's true. Um,
Hmm.
and I think, and that was one of the questions that I had for you was, that they're not mutually exclusive, working under the rehab code and having a single instruction, that they're not mutually exclusive.
That's absolutely right, Emma. And it is correct that having a joint instruction, at least initially, may help to persuade the defendant to make use of the case manager that you want to use. It may give them reassurance that you're not trying to do things behind their back, that you're being open and
Mm.
straightforward with them, but at the same time, there are good reasons why you want to make use of a single instruction later on. So it can be a reasonable concession to make use of a joint instruction, at least to begin with, when working under the rehabilitation code.
Mm. Do you find in most parts, so practically speaking, if we start under the rehab code and do an INA on a joint basis, and then your instructions as a claimant solicitor are to um, proceed on a single instruction basis, do you find that typically defendants will say, well, we're not making payments for X, Y, and Z under the rehabilitation code. Instead, you can have an interim payment, and we'll talk about it later, basically. Is that generally how things tend to go, or does it vary?
It varies enormously
Yeah.
as to the way that defendants react to this. So, some defendants at the outset will say, "We'll just give you uh, an interim payment. We're not particularly interested in the rehabilitation code, and come back to us when you've got an INA." Some defendants very keen on a joint instruction for the INA, but as long as you flag to them at an early stage that this is a strong case and really we're conceding a joint instruction for the INA, but we want to move to a single instruction later on, de defendants will be often willing to concede that if they can see that you're being open in the way that you approach other aspects of the rehabilitation, like, for instance, by providing documentation from the rehab providers, providing their reports in a timely manner, providing medical records. All of that goes towards building up the relationship with the defendants, which makes them more willing to make concessions in the way that they approach case management and the other aspects of the rehabilitation.
Yeah, yeah. It's super interesting. I was at a conference last week and there was a mix of claimant lawyers, defendant lawyers, insurers, case managers, rehab teams. There's loads of good people there. And one of the questions from an insurer was, I just can't understand why claimants pass up on the opportunity to have their rehab funded, under the rehab code for the sake of a joint instruction. I think the point was we're not trying to achieve anything other than transparency, and I don't understand why this is a big stopper, but I think that's kind of an aside, but I think the point stands that if you have the relationship with the defendant and you have that agreement with regards to openness and providing documentation and just being upfront and saying in an early call, I'm not trying to keep anything from you. This is the claimant's preferred way of working for various reasons.
Yeah, I think building the relationship with the defendant is really important from the
Mm,
claimant solicitor's point of view. Uh, and joint instructions can work perfectly well.
yeah.
That certainly in the early stages of the case, if you've got an insurer who's responsive, dealing with things quickly, it can work well under a joint instruction where authorization is coming through quickly. They're not taking points with everything that's being recommended. Then in those circumstances, a joint instruction can work well. On the other hand, if you've got an insurance company or a defendant solicitor who's taking ages to respond to things, who's with every suggested rehabilitation or piece of equipment, they're taking points, they're slowing it down. There's a danger that the claimant's rehabilitation will not be continuous, will be interrupted, delayed. That's no good for the claimant. It's no good for their recovery. And if that's what is happening, you really need to look at going to a single instruction instead, I'm afraid.
Yeah. And ultimately, that's the point, isn't it? It is the claimant's decision. And that's what the rehab code says as well. And, as far as we're concerned, if they're equipped with all of the facts and the information, um, plus experience, maybe if you're a little further into the case, then it's the claimant's choice about the basis of the instruction. They may have I find initially, um, my experience anyway, and you can tell me whether you're just different. Initially, the claimants tend to be kind of guided by you, guided by the lawyer, and saying, let's try the joint instruction and see how it goes, or we've dealt with these people before, or whatever it might be. And then as time goes on, and there's a little bit of experience under the belt, and the rehab's up and running, then the claimant might kind of change their mind
Yeah,
about that.
I think that's right, Em. The claimant quickly gets an idea of what should be happening, what to expect from their rehabilitation. And when things are taking a while to appear, the case manager has suggested something, claimant says, "Oh, that's a great idea. Definitely want to do that." But then it's taking ages to get anything out the other side. The claimant's going to have a view upon that. The claimant's not going to be
Mm,
happy with that. And if you provide them with the information, say, well, there is a potential alternative, it wouldn't be a surprise if they took that alternative
yeah,
in that sort of situation. They
yeah.
want to keep the rehabilitation going because a lot of them are really committed to the rehabilitation and maximizing what they're able to achieve.
Yeah. Do you know, in doing kind of work for this episode and talking to basically harassing every case manager I came across and asking them what their view was and what they preferred, lots of case managers said they were perfectly happy with both as long as the joint kind of worked. And the one thing that I did hear over and over again was, when I'm jointly instructed, the problem, and I wish we were doing this live so we could have people, on the comments, but do engage with us on LinkedIn about this. So lots of case managers are saying when it's a joint instruction, their main frustration is they've set out their recommendations, they've set out their clinical reasoning, and then there's just a brick wall. They can't get a response to a funding request at all, or it's just pushed, back and back and back. Well, let's do X, Y, and Z first and then C, or there's just no response. And I think from a case manager's point of view, they're trying to, their best interest is for the client. That's it. But I think it's a difficult balance in practice in chasing a defendant again and again and again. And I'm sure, I do a disservice to most defendant solicitors who are good, but there are occasions where you just cannot get a response. And whose responsibility is that to push it on?
Well, I mean, if it's a joint instruction, then the case manager has a direct access to both sets of solicitors
Yeah,
and will be asking for funding and should be reminding for the funding as well. But the claimant solicitor needs to take this in hand as
yeah,
well and can't just leave it to the case manager. They've got to be pressing for this because it's in their client's interest for the recommended rehabilitation to happen. So if the other side isn't responding to the messages from the case manager, you've got to pick up the phone and find out what's going on.
the claimant solicitor has to pick up the phone to the defendant. Yeah, I agree. This is where we're going to talk about the practicalities of these instructions, because this is where things sometimes can become difficult for case managers who would say, I'm hitting a brick wall, I can't get any response, and just want to lift the phone to the claimant solicitors and say, this is a nightmare. Like, what's happening?
Yeah.
Because that's our instinct, isn't it? And just to pick up the phone and say, what on earth is going on? So I wanted to come on and talk a little bit about kind of logistically, the proper way for communications to run where there is a joint instruction.
Yeah.
And I know this is a difficult question, Ben, because different lawyers and insurers and case managers will have different ways of dealing with this. But what we want are the practical tips here. So I'm asking you what the proper way is for communications to run in your view.
Well, I mean, there's no doubt that if you've got a joint instruction, the only proper way for the case manager to communicate is with both sides at the same time. That is how it should work.
Mm-hmm.
Now, if there is a particular sensitive issue, a family issue, for instance, which doesn't relate directly to the rehabilitation, perhaps, or the client's condition, and I can see why there might need to be a chat between the claimant solicitor and the case manager in such circumstances. That's something that the claimant solicitor needs to address with the defendant's solicitor and say, look, there's this issue. I need to speak to the case manager about this, but can you give me a bit of flexibility on this particular issue so I can do that? But it's got to be upfront. You've got to get specific clearance on that from the other side. You can't be going behind people's backs. That's not on.
It's different on every case, isn't it? It's different. But as you say, our position should always be that we're transparent and we're upfront with what's going on in the case. The defendant are going to know what is happening, whether that's through documents, through discussion, whatever it might be. So it's better, if there is something particularly for it to be raised with the defendant's lawyer, and the answer might be no, mightn't it? I
Might
mean,
be.
yeah,
But as ever, as so often with these questions, the answer is communication between the
yeah,
sides, open and honest communication, and you're much more likely to make progress in that
yeah.
way.
And most of the time, people are sensible, aren't they?
Yeah,
Most
they
of the
are.
time.
Most people that I deal with are eminently sensible and will not take silly points.
Yeah. And I wouldn't mind if I had a case where there's a joint instruction, a case manager emailing both sides and saying there is an issue, and I would appreciate some flexibility about speaking to the claimant solicitor in the next couple of weeks or about this particular issue. Um, and what do you both think of that? And having the discussion between you. But anyway, that's the point. The communication is well worth it, as always with these things. So practical, last thing, Ben, before I let you go. Practical kind of top tips, I suppose, for case managers that are dealing with I suppose the logistics of joint instructions, because it's bit, it's not as straightforward.
Um, in relation to instructing case managers, I think it's important they have a proper appreciation of everything that's going on in the case. So you've got to give them um, plenty of information about what's happening with the case. But as to whether you choose a joint or single instruction, it just depends from case to case. But you've got to take into account all the different aspects of what's going on in the case and properly give the information to the claimants that they can make a decision about how they want to proceed.
Yeah, for sure. And for case managers, I suppose, it's, being in communication as much as possible with both parties with any issues. As always, I feel like it's trite to say, and we always harp on about how important communication is, but it just is. It just is the cornerstone to everything that we're doing throughout the case, isn't it? Um, so yeah, I would be really interested, and as I said, I think it's a shame we're not in this live, because I'd be really interested to know how the case managers are feeling about single and joint instructions, and is it um is it variable depending on who is on the other side, who's the claimant's lawyer? I bet it probably is, but I'd be really interested to know people's thoughts. So please do engage on LinkedIn and let us know what your thoughts are. Thank you so much for joining us. Thank you, Ben, for all of your wisdom and your insight, as always. Very
You're very
much,
welcome, man.
very much appreciated. And we'll see you next month for another episode of Stewarts Soundbites. Thanks. Bye.
Cheers. Bye.